Hey, Jan, if you can hear me, would you either turn on your camera? Awesome, thank you.
I'm eating lunch.
Okay. I think that Jan can hear me. Can everybody else hear me?
Yes.
Hey, Vera?
Yes, I
Yep, you're
can.
nodding your head. You guys are awesome.
Can hear you.
Right, we're going to be starting soon. We're just organizing ourselves.
Okay. I can see people moving around.
And as usual, unfortunately, we're going to have you type into the chat with any questions and that sort of thing. The nice thing today, just so that you and the Zoom audience are aware, is that our speaker is not going to be using slides. So you'll actually get to see her face the whole time, which is nice because she's really nice. I like her a lot. I met her at a voting thing that we worked at, but you'll hear about that later. I'm going to turn the mic off and stop babbling at you.
Oh, look at that. Oh, my
Do you
God.
want me to cut in half or anything?
No,
Okay. I think I'm gonna turn off the TV if you don't mind.
Mhm.
Can you hand me a control so I can do that, please? I want credit for trying to help you stay healthy.
Thank you.
Just let me know if you need me to speak up. Give me a thumbs up if you don't hear something. First off, thank you so much, Maura. Thank you for inviting me. I am so excited to be in person speaking again. One of my favorite things to do pre-pandemic was to go and speak about the work that I've done in different organizations. So this feels like I'm starting to get back into the groove of it again. I'm just very thankful for you all here today and thankful for you that are on Zoom. I would love for this to be conversational. So feel free to, throw up a hand, ask a question, comment anytime. In addition to being a lawyer, former teacher, I used to teach middle school before going to law school. And then I taught at UNC Law for a number of years before landing where I am now. I am here to speak with you today about the problem with pleas. And by pleas, I mean plea bargaining in our criminal justice system. My first experience with a plea bargain was attending one with my older brother. He was the defendant. We traveled from my hometown in Johnson City, Tennessee, up in the Appalachian Mountains, a few hours away to Greenville, which was the Eastern District of Tennessee's federal courthouse. I was there with James, my older brother, and my mother, who raised us as a single parent. I was 24, so that would have made James 27. He had been charged in a drug trafficking ring. I know many people are well aware of the opioid epidemic that struck in the early 2000s and is still very, very rampant today. But he had been involved in a ring that went from the pain management clinics from Florida up through the Appalachian Mountains. And I had gotten a frantic phone call from my mother. It was the first semester of law school, and she said, "Your brother's being arrested." And this was the first that I knew of any true criminal behavior in my family, and had tried to help James navigate the system as a first semester law student the best that I knew how, and spoke to his attorney and really wasn't sure what's going on, but wanted to be there for his actual sentencing, for his plea and his sentencing. And so he had decided to plead guilty. A number of his friends and co-conspirators in the charge had already pled and been sentenced, and they'd received quite heavy sentences of 6 years, 7 years, 8 years. But he was able to, well, and in the federal system, you have your range that you're going to be sentenced, and then the judge is going to be the one that's going to decide exactly where you are. The prosecutor will give the suggestion, the defense will make arguments, judge makes final decisions. So it was the first time I'd met his attorney. He said, I want you to speak. I was like, okay, I've never seen one of these things before. Went, just told about what I remembered of growing up with my brother and what a cool, friendly, loving guy that he had been. I knew that he had gotten caught up in addiction himself, and that's what led to his selling of the pills and his involvement in the conspiracy. And so I spoke a little bit about that, and then just remember it being an out-of-body experience, watching the judge sentence him to 2 years, and to put him in handcuffs and take him out the back, and that he didn't go home with us. So that was my first experience with the plea bargain. So I had gone to law school from being a teacher, because I wanted to do immigration work. I wanted to help the populations that I was serving as a teacher that, were facing a lot of raids in their homes, and kids that were losing their parents to these immigration raids. So that's what I was focused on up until this point of watching my brother be taken to federal prison. And very quickly, my focus became the criminal justice system, because I knew that it just felt so powerful and so big and so unfair, just what I had seen and my personal interactions with it. So I quickly, and this is a weird term, but I fell in love with criminal law. I knew that I wanted to be a defense attorney pretty quickly. I interned with the Center for Death Penalty Litigation, so jumped right in the deep end, working on death penalty post-conviction cases, and it was off to the races. Once I graduated from school, became a private defense attorney for a firm, worked largely in the federal system, state system, did that for a number of years. Started work at UNC Law as an adjunct professor, doing their youth justice clinic, focusing on juvenile school cases where kids are suspended from school, as well as doing the juvenile delinquency system. And then I went private for a few years and then became a prosecutor after being a defense attorney for 7 years. I joined the progressive prosecutor, Satana DeBerry's office in Durham. When she came into office, she had approached me from my private practice, and I was teaching at that time too, and asked me if I could lead her juvenile team. And it had not been something I'd ever considered before, because I don't believe in locking people up. But after a lot of contemplation and speaking with Satana about what her vision was and what she wanted for her office and for Durham, I agreed to it. And so I was there for 2 years when the board at North Carolina Prisoner Legal Services approached me and asked me if I would go through their interview process. And that's how I ended up at PLS. So it's a very long roundabout way of letting you know how I ended up here. But are there any questions or comments about that? Yeah. So the problem, I would love to hear an estimate of how many of our US cases, federal or state, are resolved by plea in our criminal justice system. 80%, 90%, 75, 80. These numbers are from the Marshall Project, which is a respected data collection organization. The federal plea rate is 97%, and all the states' average rate is 94%. So the vast majority of every case and every defendant that goes through the system resolves their case with a plea deal. I'll walk you through quickly the process of how the case gets to a plea. You have your investigation when anything occurs by law enforcement. Law enforcement will charge the case by going through a magistrate judge typically. The person will be arrested or cited, and then the case typically at that point hits the prosecutor's hands. And the prosecutor gets to make a choice on whether the case moves forward and how it moves forward. And they do that through the indictment process with the grand jury. If we want to start talking about power imbalances, I think completely ignoring law enforcement, and that's a whole other talk. But once we get to the grand jury, these things are private proceedings. There are no defense attorneys, no representation for the defendant at grand juries. And the joke that we all make is that you can indict a ham sandwich. And so all it takes is some witness, including a third party witness being, usually a law enforcement officer that has no firsthand knowledge, sits down, speaks to a grand jury, says, this is what happens from their report or from someone else's report. It doesn't have to be their report. And so, the vast majority of cases that are presented to a grand jury get indicted. And so there's nothing that a defendant can do at that point, right? We're not in the room. The defense attorneys are not there. So we've got the indictment. That's when you're called into court. You can be rearrested at that point. You can get a higher bond put on you. And that is the point at which you're entitled to discovery, right? So that's the first time that you have a right to know what the state's evidence is against you. So as a practitioner, you start getting the reports, the CDs, and inevitably, I've never had a case in my 10 years of practice where I didn't start going through the discovery and start making my, incredibly long list of everything that's not there. There's just so much that's missing. You've got videos that are missing, you've got body cams that are missing, you've got reports that are missing, and you have to figure this out because you're reading and saying that this is pointing to this person that was there in the investigation, or that this report that was written, or that this thing was done. And you say, okay, well, let's find those things. So it's really the defense attorney's job it shouldn't be, right? But the power imbalance to build what they are supposed to have. And that's how we start to begin to build the relationship with our clients, the defendants, in a case, letting them know what the state's evidence is against them. And so you start moving forward. You have to build that relationship. You've got to let them know what's there, what the state is saying has happened. And I do this very pointedly with clients and say, this is what they say has happened. I'm going to ask you specific questions if you can respond to those. And at some point, you're going to open the door to negotiations, plea negotiations. And it's our duty to do that. Regardless of the strength of the case, we have to explore that option. So sometimes in cases, you will get a plea offer even before they've really given you discovery, like, here, this is what we think your client should plead to. And, it's our duty to go and advise and discuss that offer with our clients, regardless of what it is, and, to keep that door open. And I remember my brother telling me in his very first meeting with his attorney, that was the first thing presented to him. It's like, you're, excuse my language, screwed. Here's your plea offer. You need to take this or it's going to be a whole lot worse. And, to have that initial interaction with the one person in the entire system that's on your side and that's defending you from the weight of the government, that's really, detrimental to making choices and moving forward. But anyways, so that conversation is happening. You can, go back and forth. Clients sometimes will be like, this is what I'll take for this. And it's always the client's decision, ultimately, if they take a plea deal or go to trial. But, you've got to use all of your tools that you have and all of your prior experience and your knowledge of the system, your knowledge of the sentencing guidelines, and your knowledge of the prosecution, the prosecutor that you're working with, the judge that you're in front of, to let them know kind of how you think things would shake out if you have a trial and the weight of the evidence against them, right? So there's something that I think some prosecutors would deny exists, but it's really just a given that we call the trial tax. And that is the difference between what you get in your plea offer versus what you get if you're convicted by trial. And when I was a prosecutor, my North Star of trying to determine what was justice was always, if I was willing to resolve a case with this sentence, how is it ever just that this would be the ultimate sentence? And I worked a lot of murders and looked at a lot of post-conviction murders. And almost always there had been offers at some point in the cases for resolutions, that were less than 20 years. And in North Carolina, the default automatic sentence for a first-degree murder or felony murder is life. So just looking at that discrepancy and never being able to resolve that is something that always plagues me and continues to plague me in the work that I do today. So when you're advising your client and you're talking to them about what choice they need to make about their future, and many, many times they're sitting in jail, right? And that's a whole other talk of, innocent till proven guilty, unless you have enough money to get out of jail. So clients are usually, already in this coercive environment where, they're mistreated in a cell in a cage. And they have to make all these decisions from there. And you put in front of them, you're facing, it could be possible that you're facing every sentence stacked, run consecutive, right? And most of the time, prosecutors will indict every single thing that they think that they possibly could prove, not what they think is just or fair. So you have to advise your client that, they're facing 10 and 10 and 10 and 10, rather than the, 5 that the prosecutor's offering, right at the beginning. So just trying to walk your client through that, I think, and walking through that in your own head, you can see how easily people could accept responsibility for something that they didn't do. But for the grace of God, I've never had to make that choice myself. But if I could know that I'm going home on this date and be done with this and put all this behind me, rather than, the uncertainty of 20, 30 years ahead of me, and it's in the hands of 12 people that are very unlikely to be my actual peers, that's not a gamble that I think, well, I can't say what I would do, but it's a hard gamble to take for sure. So the vast majority of clients will take the plea offer. And again, doing now the post-conviction work that I do. So we represent all 28,000 prisoners in the state, in North Carolina state prisons at PLS. It is just so incredibly apparent. You get so many clients' narratives of how they were brought to the point of accepting their pleas, and how much regret they have for that. And you just see how many innocent people get locked up, or people admit to, they might have done something wrong, but not, what they were ever charged with. And then they were coerced with the 5 or 6 charges rather than the one thing that they actually, did. And they're just, brought to their knees to accept the plea. My husband is the chief public defender of Wake County. And he recently let me know that he's taking a death penalty case that's set for trial next year. And if we want to talk about the ultimate coercion, that's why I think the death penalty still exists in North Carolina, is not because there's wide popular support for it, but because prosecutors lobby for it because they need it as a tool to force their pleas. Because in but many first-degree murder cases, they always put that on the table and say, if you plead to life, we'll allow you to plead to the rest of your life, or we'll go for your life with the death penalty. And that's even in very, very liberal places, right? Like Wake County. Or liberal places. Yeah. But they absolutely, use it as an extreme, I guess the most extreme tool of coercion, right? Any questions about the process? Whenever you're actually giving your plea, you've probably seen, Law and Order, the normal criminal justice shows, and the judge engages in a very, very short conversations with defendants, and they're listing the constitutional rights that you're waiving. Do you know you have a right to a jury trial? Do you know you have the right to have the state prove the evidence against you? And just I guess, after a decade in it, you get desensitized to it, but it's just how quickly you watch someone just take away their rights. And that includes rights to appeal, because you wipe away so much of what you can actually do on post-conviction or appeal. If you're doing a plea, you actually explicitly waive your right to appeal in some of your pleas. And yeah, if you want to get back to the documents that this country is founded on, who would have imagined that this is where we would be so soon after being founded, that the vast majority of people that get caught up in the system, are forced to waive almost every right that they have. Something to think about there. Yeah. Yes, ma'am.
Does that apply even if there's new evidence comes forth that
So
they can't appeal, or? No, wait, I'm
Yeah.
getting confused.
if you plead guilty, you're the state has to give a recitation of the evidence that they would give in a trial. So they have to put something up there. They have to say, something occurred. And if you ever sit in court, you will see too how pitifully inadequate it can be. And it's procedure. The judges have to say, okay, I find that there's sufficient evidence, or that there would have been sufficient evidence against you. So there can't be nothing that's said in court about the evidence against you. Does that kind of address your question?
All right. Atish?
My question is, if the situation was reversed, like rather than 97% of the cases going for plea bargaining, only 3% of the cases will say, what would happen to the justice system?
It would absolutely crumble. So a lot of the proponents of criminal justice reform, true reform, really, really, really push practitioners to encourage clients to take their cases to trial. We are experiencing a really interesting inflection point of post-COVID, where there were so few trials. I mean, what we've got are these insane backlogs of people sitting in jails for 5-6 years before trial, with nothing proved against them. But absolutely, the system would crumble. It could not function if 97% of people took their cases to trial. And I think what would happen is that you would have much less things indicted, right? The prosecutors would be forced to exercise a much higher level of discretion in what they're bringing forth, because there would be no way to get through the cases. There'd be no cells, pretrial cells to hold people in. It would flip the system on its head. And I wanted to circle back to this question. I think you might have also been speaking about newly discovered evidence after a plea, if that could be used. And absolutely, it can. That's one of the caveats for post-conviction work, is if there was misconduct discovered by the prosecution or the defense or any of the officials, or if there's newly discovered evidence, then you can bring a case back up through a motion for appropriate relief. Yeah. Were there any other questions, Maura? So I would jump over a little bit to speak for a moment about our juvenile justice system. Justices. And I think that there's an additional layer of coercion to it, maybe two additional layers, right? The first is that we're dealing with children who are inherently more malleable, right? And, I think law enforcement and most prosecutors would say, that we've created this system that is broken down to a level that juveniles can understand what they're doing. And I would tell you, we absolutely have not. If you have your plea soliloquy form, it is almost identical to the adult ones. Maybe the language is brought down just a little bit, but they're incredibly hard concepts to wrap your mind around, even as a adult who's been studying this for decades. And so, kids are much more susceptible to false confessions. If they're sitting there being, berated by law enforcement, there's no true, law enforcement can still lie to kids about what they have against them to get them to confess to things. But then you also have this additional layer of coercion, which is the threat of transfer to adult court. So the way that things are set up now, 16 and 17-year-olds, you have the ability to transfer them to adult court for many, many things that are not that serious. So you can always say, you need to take this plea or we're taking you to adult court and giving you permanent records up there. So just, all different considerations for the most vulnerable members of our society that are just completely overlooked. So clearly I've struggled, or maybe not so clearly, but I have struggled in my career as to where my best work or the best impact I could have would be as a defense attorney, prosecutor, administration, post-conviction. Where can I do the most to actually try to change the system or to help the most people that are caught in the system? And I truly, well, let me ask this question. What actor in the system do you think is the most powerful? Which actor in the system do you think is the most powerful? And I'm asking amongst law enforcement, judges, defense attorneys, prosecutors, clerks, prosecutors, probation officers. Yeah, that's where I keep landing, having tried them both. Prosecutors have so much discretion, right? They get to decide really who to proceed on who they proceed on charges against. Even if law enforcement arrests somebody, they can just say, nah, no thanks. This is a very odd aside, but I was just listening to a podcast in which it was talked about how JonBenet Ramsey's parents were actually indicted. And the prosecutor was like, oh, no, we're not going forward on that. That is a true fact, right? And it was for like child endangerment. But yeah. So prosecutors have limitless discretion, right? Maybe not so much. Well, so I am an abolitionist on one hand. I don't really believe in our system anymore. But I think if we need to talk about how to change it the quickest, the cheapest, the fastest, and the most completely, it's get progressive prosecutors. Get prosecutors who will truly exercise discretion, who truly understand the community impacts of every prosecution that they do, who believe that the people that they're prosecuting are people and not numbers or conviction rates, and who are willing to grapple with the tough questions. So there's one solution is to truly move towards the progressive prosecution movement. Yes. At the end, I can't shake my teacher roots. I can't.
Prosecutor versus defense. Whoever wins the most helps the weaker, the defense, it's good for them. So that's, is that follow?
I don't think so, not inherently, right? So if the system was truly set up in a way in which the playing field was even, then there would be no issue with the adversarial system in my mind. It's the fact that the resources are so imbalanced, right? Like the state has all of law enforcement, they have the crime labs, they don't have to ask for money for expert testing because they have their labs in their pockets. They have the district attorney, the conference of DAs, which is a whole office of the state that provides resource counsel to prosecutors that will send in special prosecutors. The power imbalances, they have the ability, to put you in jail and not let you out until you resolve your case. It's a power imbalances that are the problem. They also exercise complete calendar control in our state, which doesn't seem like much on its face, but has a huge impact on our clients' lives. They're able to set our cases when they want to set them. They set them before which judges they want to set them in front of. They can just casually demand that your client come to court, once a month for the duration of however long they're waiting for their trial. Which, literally those things are like, hi, I'm here, and they leave. Like everyone knows nothing's going to happen with the case, but yet they're pulled away from their jobs, for hours and hours every month, just because the prosecutor can do it, or else put them back in jail for violating terms of bond for not showing up at court. There's just so many layers of control that prosecutors have that makes the playing field unfair. Yes, ma'am.
Our Zoom audience can't hear.
Oh, so what can we do to start to change this imbalance?
This is my easy softball answer, but education is a really, really big one. I think that we are at this incredible moment in our history where the tide is turning in regard to the answer to crime is not just to lock everyone up, and is not just to lock every Black and brown young man up. There's actual, true conversation going around about prevention. That there needs to be things done on the front side before people are thrown into the system, and facing all the things that we've spoken about today. I think that restorative justice is the true answer, even higher answer for me than, progressive prosecution. And there are some really cool restorative justice models that are being worked in Durham. And those are outside the prosecutor's office, right? Those are community-based organizations that are stepping up and saying, we know what's best for our communities, and this is how we want to get there. And it does take prosecutorial buy-in, and it takes defense buy-in. It does not require judicial buy-in at all, because they're left out of it until the very end. But the restorative justice model really sits everybody down, and it takes a really long time. And it's very, very, very time and labor intensive, where parties work with the harmed parties and the harming parties to learn, to answer as many questions as they can as to why this happened, and to learn from the people that are harmed. What do you need? What would move you forward? And something that I heard very, very much as a prosecutor working with homicide victims' families over and over again is, none of this means anything to us. Like, this is not going to bring our person back. you know, I feel like anytime we're talking about a plea or terms of years, that's trying to quantify the value of the life of my lost loved one. You know, victims, there aren't true spaces for victims in the criminal justice system. You know, there are laws that require notification, but that's not consultation, right? That's like, this is what we're doing. There's a space in the actual sentencing for victims to give their impact statement, but it doesn't change the outcomes at all. So I truly feel in my experiences that the restorative justice system is where, you know, victims are truly heard and perpetrators have to really and truly face, you know, exactly the harm that they've done and try to work through, you know, how they can not do that again. And if you look at our recidivism rates, they're abysmal. They're abysmal. I was in it was the sentencing commission, our state sentencing commission meeting a few months back. And, you know, they've got these staff members who are amazing at working the numbers and showing, you know, the data of what's happening. And they're impartial and they're great, the staff, but, you know, the sentencing commission is all different actors, stakeholders in the system, and lots of law enforcement and not a lot of defense attorneys there. Actually two defense attorneys out of like 20 something. But yeah, so our recidivism rates are over 50% within 2 years of getting out of prison. Over 50% of people are arrested again. And so there was no conversation in this group, in this presentation, as to what that meant for our criminal justice system and our correction system. But I couldn't help but think, like, is no one going to stand up and say, like, our system is failing? Because that's exactly what that means. So I think that there's nothing that we can do to make corrections move humanity forward. I think that's inherently inhumane. So I think it's a whole different model. I'm sorry, I just took you off to La La Land with, yeah.
I actually, we have a question from the Zoom audience.
Yes, please.
So Jan mentions, in cases on appeal, prosecutors use the defense's plea of guilty against them, no matter what proof of innocence exists. Is there any way to get around this?
You know, one of our US Supreme Court justices said in an opinion that our system prefers finality over justice, and that's incredibly true. I mean, there are just so many procedural stops to getting, you know, justice served in many of these cases. Once a case is resolved, you know, through trial or through plea, it is so incredibly hard to get a different outcome. And that's with, you know, two steps that you have. You have the appeal process, and then you have post-conviction. So yeah, yeah, I mean, it's just very true. And there are those small caveats of the newly discovered evidence, the misconduct by any of the court actors or investigators before the conviction that kind of open up the door. But a lot of that has to be done on post-conviction and not necessarily on appeal. Appeals are limited to the paper records. So, you know, think of how limited you are in a plea. You have your indictments, any motions filed, and the plea transcript in most files that an appellate attorney is looking at.
I think because of time, we need to, well, Jennifer, how about you're the last question? Go ahead. And then we'll move on. Do you have somebody coming in behind us today?
Oh, I was gonna wait till the end. I had a couple questions, but I'll start with this one. If you could explain what was the original intention of the grand jury? It seems like there's this, it's a, if I'm sitting on that grand jury and only one person comes in and says, hey, I got all this evidence that someone has done a crime, then it seems like that would, of course, tip them to going forward. So I'm just wondering if there was what was the intention behind setting it up this way?
I don't know historically. I don't know historically. I think that, the level of distrust that would be required of law enforcement witnesses in order to even start to level the playing field is not something that we're going to reach. You would have to walk into that room saying, I'm going to question the validity of everything they say. Because who wouldn't vote? You're exactly right. This was stolen. I saw him do it. I took his ID. Please indict him for larceny. Like, that's the proceeding. And it takes 5 minutes, 10 minutes, even on like a murder. It is insane how quickly it happens. I guess not if, only one side of the story is being put up, but no defense at all.
So I think what we're going to do is thank you for your talk, but we will have some time in a brief moment for general questions if you'll be willing to answer those.
Absolutely. Absolutely. Thank you.
Thank you very much for a very thought-provoking talk. And of course, now I'm thinking, well, can we hear about all these other topics? Because it all goes together kind of. So this is where we pass our baskets. We are an all voluntary organization. And if I could actually read, it would be helpful. Yeah, we're an all voluntary. You guys know the drill, right? We pass the baskets because we don't have any income from any other source other than our pledges and our collections. So that's why we do it, and we appreciate your support. Yeah, we will go into Q&A now. I'm gonna say ahead of time that I'm gonna call it at 10 to 3 if we still have questions. So that's 15 minutes. We do have a group coming in behind us, and we want to make sure we have time for Tisha's wonderful refreshments. More casual questions. Okay, so the way we do it is we go to people who haven't asked first, and before we go back around to other people who have asked, and we ask you to ask only one question and or one comment as opposed to multiples.
All right, if you welcome to come back to the podium, and I just wanted to have a chance to do the basket passing and stuff. And all right, so I'll do the mic running.
Okay, we have another Zoom audience question. You obviously caught everybody's attention. So Anne actually has a question which I thought was fairly interesting myself, which is there a country in the world whose justice system you most admire?
Being an abolitionist, it's hard. I would say our Scandinavian countries have it much better. Their recidivism rates are lower, and one hallmark for Europe, Eastern Europe, and Western Europe in general is people aren't going to be serving over 20 years, around about that for anything. So they actually do have a focus on rehabilitation, right? Because everyone is going to be getting out. And so, yeah, they spend more money on the people that they do incarcerate, but provide a lot of true rehabilitative services in that. And I mean, I can get into it, but, our prisons aren't even providing true substance abuse treatment. So, yeah.
So I'm going to take Mike Runner's privilege and ask a question.
Yeah.
We've previously in this room had a discussion about bail system in this country and its problems, particularly the way it's used as a kind of a weapon against people. As a prosecutor, how can you tell us more about that and what you think a just way to make that system work would be?
Sure, sure. So if you look at our bond statute, right, it has a laundry list of things that our judges are supposed to consider in setting any bond. And primary amongst them are, the person's likelihood of coming to court and potential dangerousness. And so I feel like those two things, the conversation about will this person come back to court, which is right, that's primary, is almost never ever discussed. It feels very much like it's a political act of everyone playing hot potato between the prosecutor and the judges. If this person gets out and does something wrong, I want to say that I didn't recommend this. It wasn't me. It was you. It was you. And it's just really clear from the way our statute is written, that that's not the conversation that's supposed to be had. It's, does this person have ties to the community? Are they taking care of people? Do they have dependents? What is their work history? Have they been in trouble before, and did they come to court before? Right. So I feel like unless it's the most dangerous crimes, it should just always be the default that people are just released on their written promises to appear. And it is the craziest feeling, right? Like I had this case, I don't want to go into it too much because it was nuts, but someone was alleged to have killed their parent, and they came from a lot of means, and that person literally walked in and walked out of court. And watching people get caught up because they're selling dime bags of weed, and watching people sit, for weeks on completely nonviolent things, and victimless things, even, beyond substance abuse things, is mind-boggling. But it is really hard, even with my history of defense and my personal connection to defense, that when you're feeling the pressures from all around to stand up and say, like, I know what everyone else is doing and thinking, but like, you need to do the right thing and let this person out. It's still hard. So yeah, it's going to take an atomic bomb to the bond. Well, and also we have way, way, way too many bondsmen lobbying our General Assembly. So that's what it's going to take, getting them out.
I practiced law for a very short time, only 4 years, before I realized I didn't like it. But one of the cases that still haunts me to this day was a sort of it was a plea bargain. I get the document. I was court appointed, misdemeanor case. Go in, search the house. They find some drug paraphernalia, and they're putting my client on trial. And I get the paperwork, and I hit the feeling of elation. I was so happy, like, we're getting this dismissed. Because what I found out was the paperwork for the application for the search warrant was the day after the search warrant. So completely wrong process. And I'm going, we're going to get you off because that's an automatic. So we get into court, and I let the prosecutor know, no, we're going to court on this one. And they said, before you decide that, let's have you talk to the arresting officer. Unfortunately, that's what I did. And when I pointed this out to him, oh, that was just a clerical error. I really did date it on the same day, hours before and all that. And he goes, plus, the drug paraphernalia we found a spoon that had burn marks on the top of the spoon. And I'm like, are you positive it was on the top of the spoon? And he's like, oh, yes, complete. And it was like, well, from what I know about heroin, it should be the bottom of the spoon. He goes, oh, I made a mistake. No, that's it. No, that. So what it came down to was this cop was going to lie through his teeth. And who are they going to blame? Who are they going to believe, the cop or my client? So I ended up having to plea bargain for the poor guy. Is there anything I could have done different?
It's so hard because it's not your life that you're making decisions for, right? And so, the best that you can do as an advocate, the attorney, is to counsel the client. Like, this is what it is. This is what I think will happen. This is what I've seen happen. And ultimately, it's your choice. And it is really hard. A quick anecdote. We had a client who was convicted as a 14-year-old, whom one of my amazing attorneys won in our North Carolina Supreme Court his case, with a wrongful confession and, just a total mess of a case. She won the beginning of this year, and his case got sent back to trial level, as they ordered a new trial, is what Supreme Court did. They could have just overturned it, but we take what we'll get. So the judge gave him the same bond that he had actually paid and was out on before his conviction. So the $500,000 that he had paid 20 years ago, gave him that same bond, would not come off of it, despite what the Supreme Court had said. And there was no evidence now, mind you, because we were likely to win the wrongful confession issue. We were going to relitigate it. And the client came to us and said, or the DA gave us an offer of time served. And the client said, yeah, I'll take it because I want out. And this was an innocent 14-year-old. And as his advocates, me and his attorney just cried, because we couldn't even counsel him to not do that, right? He just sat in prison for 20 years for something that he didn't do. And he just wanted to go home.
Those are hard stories. I'm coming back to our Zoom audience who are interested in a different story, which is to say your brother. One of our participants wants to know how he's doing. And another participant asked, best case, how would you envision your brother's case should have gone?
So James is doing pretty good now. He got out, immediately started working. He's struggled with his addiction since then, and now it's been 10 years. But he's doing well. He lives on the coast and works and lives a bachelor life. Best case scenario. He benefited from what's called the safety valve in the federal system. So it's basically like a first offender, nonviolent offender deal that he got. And it was really nutty because all of his co-conspirators cooperated against each other. And this is going off on a big tangent, but it's called ghost dope, where everyone that talks and says you did something, those numbers are just added and added and added with no real verification other than we can prove that you did something wrong, but everyone says you did this much wrong. So we're going to sentence you for this much wrong. He was able to benefit from the safety valve and not get caught up under that. What would be fair in that situation? I think, if they'd given true rehabilitation to all of those young men that were caught up in that ring. Some of them are dead now, from their addictions, and life's not pretty for most of them. So, I don't know what kind of, how are we moving the ball forward in any way if we just lock people up for a few years and set them back out to continue doing what they were doing. And
Hello. I have a very good friend who has a loved one who's in prison. He was convicted for being a felon in possession of a firearm. This was after someone had threatened his life. So now he got the 15 years. It had something to do with other things from his past where he had already gone to jail for it and served time for it. Now, one of the crimes was something he was convicted of maybe 20 years ago, when he had a girlfriend. He got into an argument with her, and he took back something he gave to her. So the conviction was common law robbery. Now, she has since said she wasn't feeling in danger of being harmed, which is one of the things for common law robbery. And my friend is trying to find a case where someone was convicted of common law robbery and they later lowered it to larceny, because that would help him a lot.
Yeah.
There would be a possibility of them lowering his sentence. I wanted to ask if you know of any cases where someone was convicted of common law robbery and it was lowered to a lower offense, such as larceny.
Yeah.
Yeah.
It's hard.
Or how she might be able to find that. Like,
Yeah.
if you don't,
Is that a federal conviction?
it's a federal, yes.
Yeah. I'm trying to think. I mean, that requires post-conviction relief, right? So somebody's going to need to go into the first conviction jurisdiction and litigate that. Off the top of my head, I can't think of that case.
By the way,
Yeah.
he was coerced
Yeah.
into taking taking a plea bargain. And his first judge, his first lawyer did so many things where it seemed like he was against him, where he would say no. Like, my friend would try to, she would tell him things like, what about this or what about that? And everything was no. At one point, he even told her he deserved what he got.
Yeah. So, I mean, it does sound like it's possible that someone could go in post-conviction with an affidavit from the victim of newly discovered evidence. It's possible. Okay.
Where it was lowered, his lawyer now is a better lawyer.
Perhaps we can continue this after we finish, and you can have one-on-one, and that would work. So I'm going to turn the mic back to Dorothy.
Thank you so much. Okay, we're on for announcements. Mary.
I just thought it would be helpful for our visitors today to let them know about the upcoming meeting schedule in terms of in-person Zoom.
Oh, yeah, that gets a little bit confusing. Yeah, so Maura, can you talk about upcoming?
We're being a little slow here. Hold on a second. It would help if I were actually organized here. The next 2 weeks are going to be Zoom.
And that Zoom only. We will
Zoom
not
only,
be meeting
because
here.
the next Sunday is, as everybody knows, second Sunday of the month, which is automatically always Zoom. That's going to be a really interesting one, actually. That's it's going to be called the critical race theory confusion. And one of our ethical humanist leaders, Hugh Taft Morales, is going to be giving that talk to us, and he's really good. So I highly recommend that one. The week after that, October 16th, is also Zoom, because the other group that sometimes has this room on Sundays beat us to it. So 2 weeks in a row on Zoom. The week after that, the program has not been 100% finalized, but will be shortly. That would be the 23rd. October 30th is the last Sunday of the month, and it will be here in person. And in fact, it's the membership meeting. So possibly slightly less interesting to some people, but I think it'll have some valuable information. You're right.
thought
I
that
missed
was at
one.
you too.
The 23rd is in person. and it's the membership meeting. Gretchen's absolutely right. And Mary, we can wear costumes on the 30th, but it won't do us a bit of good because Gretchen's right. There's an all AEU presentation on the 30th. So in fact, it's not only not here and only on Zoom, but it's also not at our normal time because the all AEU ones tend to be at what, 11, I think?
11. Our newsletter that goes out usually Monday, Tuesday, or this week, Wednesday, gives the details. But what I'm hearing is for 2 weeks, we will not be meeting here. Then we will be here on the 23rd,
Yes.
and then we won't be here again for the 30th. We'll be meeting all of those times, but on Zoom. I wanted to announce that Jennifer is taking over as Change for Change coordinator, which I greatly appreciate. So if you have ideas, or Jennifer, do you want to ask for ideas or?
If you have local charities that you would like to see in the Change for Change jar, just let me know. Otherwise, I will look and find some local ones myself. Thank you.
And the jar is here today without a designated recipient, but that doesn't mean you can't throw in your small change and small bills to help when we make that decision. I want to thank our volunteer. Oh, sorry, Fred.
I have an announcement as well. I'd like to just mention to the group that we have a new member officially. Solomon Gibson was approved by the membership committee. So that's it.
And that's a really difficult process. 3 of us circulate an image of the application and then say, okay. I mean, it only would be difficult if somebody put something awful down on it. And no one's done that yet. I want to thank our volunteers today. So Mary, our greeter, myself, board member in charge, Atish for refreshments, done all on his own. Thank you very much. No. Okay. Okay. And Blue for opening and closing words, and of course our speaker, but Blue, let me turn it over to you for closing words.
This is called I Thought I Could Sympathize for Lamont's Son. Local blues band performs at local blues bar in suburbia, USA. Invited friend, only black skin in white-filled bar stools. Acknowledge the unbalanced equation. Share stories of moments of realization. Studying in DC, I'd ride the bus. Only white skin is in black plastic-filled seats. A visiting girlfriend in Northeast DC, 4 black men huddled around trash can fire on cold January night. Only white skin on black filled streets. Yes, he answered. But once you were off the bus or out of the hood, you were still white in the city of white legislative votes, white majority court rulings standing in front of the White House.
I've been really remiss not to name our speaker by name, Beth Hopkins Thomas. I sent out the announcement, but it didn't, anyway. So I wanted to give you that full name recognition so you can build a reputation with us. Anyway, our meeting is over. So thank you all very much for joining us, and please join us for refreshments.
I'll advise everyone to wash their hands.